I'm Doug Wood. I'm the founder and the National Director of Americans for Responsible Technology. I really appreciate your logging in, being here this afternoon. The purpose of this webinar is to bring you up to date on what's happening on the wireless front in California, and to familiarize you with a couple of bills that are making their way through the California legislature, and encourage you to communicate with your California legislators about these bills and to submit comments to the relevant committees, which will be hearing these bills in the really near future. And the details on how to do that is going to be coming up in this webinar, so pay attention. Before we get to what's happening in Sacramento, we're going to hear from two of the lawyers involved with a lawsuit brought in Los Angeles County by the new coalition called Fiber First Los Angeles. The lawsuit is against the Los Angeles Board of Supervisors, and it's related to the passage of new zoning ordinances in LA County, which pretty much ignore California's environmental laws. They eliminate public participation in antenna siting decisions and just generally greenlight the installation of a lot more wireless antennas in LA County. And then if you have questions at the end, after we've covered all those things, if you have any questions about the petition that was filed recently by ART, I'm happy to answer those questions. And now it's my great pleasure to introduce to you Attorney Scott McCollough. Scott has a long history of regulatory law practice and argued the successful case against the FCC for Children's Health Defense in EHT et al. V. FCC. Ladies and gentlemen, Scott McCollough.
Hi, everyone. Glad to see we're starting to get a bunch more folks piling in, talk about these important subjects. My topic tonight is a brief overview of the lawsuit that we have filed challenging the county, Los Angeles County's amendment to its wireless zoning ordinances. We have 11 plaintiffs. Fiber First LA is the lead plaintiff. We have several minority organizations. We have a couple of unions. We have some safe tech organizations. We have some Native American tribe, and we have two groups of children advocates, the Mothers of East LA, and then Children's Health Defense, which is my primary client. We've all come together because we all believe that what Los Angeles has done could well turn out to be a model for other local jurisdictions. And we think that what they have done needs to stop in LA. There are several lawyers on the team, Julian Gresser, who you'll hear from, myself. We have secured fine local counsel, Mitch Tsai, TSAI, of the Tsai law firm. Bobby Kennedy is also on the papers, but as some of you may know, he's taken a brief leave of absence to do something else. Let me just try to very briefly talk about the 8 causes of action that we raised. The main one, as Doug mentioned, is the environmental claims. The county found that this ordinance, which may end up authorizing the construction, placement, and operation of thousands of wireless towers in the non-incorporated areas of Los Angeles County, thousands of them, was not going to have any environmental effect. That's a preposterous assertion. As we put in, and we told the county while they were considering this, there is an extraordinary amount of evidence that wireless facilities, their operation, and in particular the RF that comes from them, has devastating effects to people, especially children, to all other aspects of the environment, what I call the birds, bees, and trees. There's an astounding amount of evolving evidence showing that when you put one of these towers in, all the wildlife goes away. Bees die. People who used to have all sorts of wildlife in their backyards no longer have it. Animals that do stay end up starting to get tumors and all sorts of other afflictions. And they pretended there's not going to be any effect here. But there are other environmental effects as well, setting aside just the health and environmental impacts of the radiation itself. Building these things does disturb the ground. The operation of wireless itself is simply an energy hog. It uses far more energy to transmit the same kind of information, or at least the same amount, as would a fiber connection to the home. All of these facilities being put in place will contribute to climate change at a time when your state, California, has been doing supposedly everything it could to reduce CO2 emissions, greenhouse gases, and reduce energy consumption. But here they are placing these things out here without even a look at the environmental consequences of what they are doing. Now, we are contending that the California Environmental Quality Act requires that the county perform some kind of analysis of the environmental impact these facilities will have. It doesn't have to be necessarily a full-blown environmental impact statement, but they have to at least look at it, try to decide what the extent will be of these, and once they find them, see how they can mitigate them. The county, on the other hand, said no, it's completely exempt, and we are challenging that exemption. If the court agrees, then it will send the matter back to the county. It will be required to perform an analysis before it can pass the ordinance in its current form or in any other form. The second claims that we make are somewhat arcane and procedural in nature, but still they're very important. One of our other claims is that this ordinance does not comport with the general plan that Los Angeles County carefully put together, large portions of which, by the way, deal with environmental impacts of things. This ordinance doesn't cross-reference to the general plan. It doesn't comport with the general plan. And under California law, an ordinance must be consistent with the general plan. So we are hopeful that the court will recognize this and send it back and require that the county change the ordinance so that it matches up with its far more environmentally protective strategic plan. We also noticed that at the very last minute, some very significant changes were made to the ordinance. Under California law, significant changes of this sort must be sent back to the Planning Commission, which must have an opportunity to take comment and pass on them. That did not happen here. So we think that the court should send it back and require that it be referred to the Planning Commission before the supervisors can adopt the ordinance in final form. Now, let me get a little bit to the substance. One of the main problems that we have with the ordinance is that it was basically written to be a rubber stamp. Most of these facilities today, or at least under the old arrangement, had to be a discretionary conditional use permit, where there was notice to all of the people in the area. People had a chance to come in and comment on the application. There was a hearing. Either the planning department would issue the permit or the planning commission would. There were rights of appeal, and ultimately it all went before the Board of Supervisors on appeal. The way that they've written this, there is none of that. None of it. It's all what they call ministerial. An application will come in, some functionary at the staff level will look at it, they'll check a few boxes, and if everything is there that their rules say needs to be there, it gets stamped approved, and it's back out the door within 5 to 7 days. To the extent that anybody gets any notice at all, what we're finding is the notice arrives after the permit's already been issued. So that's a real problem, and that is the focus of several of our points of error. We contend that the ministerial process is what we call an invalid delegation of legislative authority. We contend that it violates the nearby residents' due process rights. We contend that the way that the ordinance is written, it's not really ministerial anyway. because there are some areas where the staff, if they're of a mind, they can require some changes. That means it isn't ministerial, it is discretionary, and therefore it does not qualify for ministerial type processing. Again, there must be full notice, a hearing, and an opportunity for appeal. So we have these environmental claims, we have these other procedural claims, and then we have the really important claims that go beyond just environmental, and that is, what rights do people have when a wireless company proposes to put one of these facilities, perhaps right in your front yard in right of way? Do you have a right to notice? Do you have a right to come in and tell this governmental organization, your elected representatives, what you think about that? Do you have any procedural rights to it? Can you appeal? Can you appeal it to the Planning Commission? Can you appeal it to the Board of Supervisors? Here, the answer is always no. And we think that this is a fundamental deprivation of people's rights. Folks will be affected when one of these is proposed in their area. Yeah, they will be affected when one of these things is beaming their energy into their children's bathroom or bedroom window. And we think that above all else, the court needs to preserve people's due process rights to participate in government and let those in authority know what they think about all of these wireless facilities that are already popping up and will soon be popping up even more throughout the rural areas of LA County. If you have any questions, please send them on in. We'll try to answer them. I'm sure Doug can moderate them. And if you have some afterwards, I think most of y'all know what my contact information is. I'll be happy to try to answer.
Thank you, Scott. We're so fortunate to have you and Julian working on this case. And speaking of Julian, let me introduce Julian Gresser. He is an international attorney, professional negotiator, inventor. He's the chairman and president of Big Heart Technologies. He was twice Mitsubishi visiting professor at the Harvard Law School and a visiting professor at MIT's program on science, technology, and society. My pleasure to introduce my friend Julian Gresser.
Thank you, Doug. I'm going to provide just a very brief, perhaps larger window and some of the backstory underlying what Scott said, but I thought his presentation was so clear and persuasive that I'm not going to repeat it in any way, but perhaps you can just take my comments, which will be brief, as subtext to what he said. First, I think that this case is seminal. It will be cited. It will create a model, as Scott said. And it's emblematic, I think, of a shift that has happened, perhaps imperceptibly, in our country, in which corporations and government functionaries and those in government who are responsible at the state level, at the local level, as we're seeing in Los Angeles, and at the national level, have become comfortable with a fundamental disdain for law. I think this is an important point worth highlighting. What we're seeing in Los Angeles today is not limited to Los Angeles. As Scott said, it's not a problem of law. The law is really clear. The problem that has now insinuated itself in our society is that these people, these boards of supervisors, have so much arrogance and they are under so much influence of these companies, they feel it's no longer necessary even to bother to observe the law. I think that this represents a shift from when I was growing up and when I was a younger lawyer and so forth. I grew up in the heyday of the National Environmental Policy Act, the Clean Air Act, all these wonderful, the creation of the EPA, all of it's as though none of that matters anymore. They really feel they can just get away with it because there's no checks, no balances. That's the first point. The specific way in which this instantiates is in terms of the California Environmental Quality Act, which Scott said, they just brush aside as though it doesn't even apply. They feel that they, by Russian use, can categorically exempt their responsibilities, which are clearly laid out under CEQA, without any kind of by your leave. they feel there's no need to create a record to even justify their conclusions. This is what is at stake, not only in Los Angeles County, but throughout California, because of the influence of Los Angeles County being such a powerful and influential body. And it will soon be taken up as a rallying call across the country. This is partially what is at stake. Now, you have this fundamental disdain for law. It is a natural tendency, like a magnet, to draw toward autocracy. And that's why they really are systematically trying to cut the public out. The public voice no longer matters. And Scott gave examples of how you could have a tower showing up right next to your child's bedroom without even proper notice or an opportunity to object. That's what's at stake in this case. So due process is really the victim, in addition to these environmental laws, which are directly applicable. I think it's important, since I've just published my autobiography, to point out, which is a theme of the autobiography, the question of for whose benefit? What are the operative values that underlie this kind of lawless behavior? And I submit to you what has happened is, there's a wonderful book I would recommend to those. It's had an influence on my own thinking called The Nutmeg's Curse by Amitav Ghosh. And he gives the history of what he calls extractive capitalism. And this we're seeing today, this sort of the excesses and the pathology of a system that has indeed brought, I'm the first to say, some huge benefits to the world, but it's become malignant. And what we're seeing here is you ask yourself, well, what is the values for whose benefit? And it's clear that the benefit that is being asserted is really the shareholder benefit, the investor benefit over the public interest. And it is backed with a muscle of, which is as ancient as Plato's dialogues, that we have the power and who cares about you? It's called might makes right. And I submit to you, as I suggest in my book, that might makes right is going to take us right over the precipice. It's going to injure the most vulnerable in our society, but it's going to implicate everyone. And it is not a set of values that are going to allow us as a community and as a society to survive. So we have to begin to think about what are the values that will enhance our survival, that will increase and contribute to peace, to compassion, to kindness, and to getting on with one another, not by having these things rammed through, which is what they're attempting to do. So what I'm trying to suggest is there are issues in this case that transcend the specific counts that Scott enumerated, that are deep, that are fundamental to where the society is going. That's why this Los Angeles case is so important. I'll just make a few observations as follows. This is a very specific case, and as lawyers, we do our best to craft the case in a way that optimizes the most powerful legal arguments. But I think we must do more now, because otherwise these will be one-off attempts. And it's true, if we score a victory under the way our legal system is set up, it will create important precedents that can be copied. But I think it's really important to realize that all these cases, whether it's Doug's FDA petition or ART's FDA petition, or Scott's great victory in terms of the FCC and the remand, or what we're trying to do in Tahoe, or Odette Wilkins' valiant struggle in New York, they're all connected. They're all part of a mesh. And we have to begin to understand and approach these cases from what I would call from a systems point of view, to understand what are the critical issues and how they can be applied in many other contexts. The disdain for CEQA is part of a larger pattern, some of the audience may know, to try to basically effectively repeal the National Environmental Policy Act through what are called categorical exemptions, piecemealing, segmentation. These are issues we see in Los Angeles because they're trying to sort of boil it down to permits, and now through this legislation, batching these permits. and rush them through. This is a common pattern. We see it with satellites, where the FCC is taking the position they don't have to assess any environmental impacts of anything to do with satellites because they're all categorically exempt. The same argument we're seeing here in Los Angeles. So approaching it from a systems point of view, understanding where are the vulnerabilities, what are the critical issues. The second point is to pay attention to the victims. The situation in the United States is set up by these telecom companies and their compliant bureaucrats that nobody's monitoring anything. Now, you can't prove a case in damages unless you can show the dose effect. The dose effect has two, at least most rudimentary components. One is how much radiation is being put out into the communities. And second of all, what is the connection to that level of radiation to injuries and symptoms? Nobody's assessing any of it. Now, we happen to have the tools. There are technologies that exist right today that could enable communities in Los Angeles, in New York, across the country to understand and measure precisely, day in, day out, over weeks and months, even years, what is the cumulative impact of this level of radiation? If we don't begin to measure it, we're not going to know. We have the capacity today to measure it affordably. We ought to do that. The second is we ought to be taking surveys of people being injured. The government, the EPA, the FDA doesn't have a clue who's being injured. That's because they don't want to know. Communities, local communities must begin to do surveys, understand who's being injured, what are the symptoms, what are the illnesses, and overlay the map of the exposure so we begin to take what looks like very abstract material and make it concrete and specific. Once we're able to do that, we will surely discover that the problem is far more enormous than we even imagined. The key point in the United States today is most people don't want to know. And we have to create incentives for them to find out and to deal with these issues. The last point, which, as you probably know, diversity, equity, and inclusion has become a shibboleth now of the Biden administration, but it's being used, and I'm saying it has some great merit, no doubt, but it's being used cynically to misrepresent and to inveigle communities into believing this propaganda that these companies are putting out. In Los Angeles, they put out, it's going to solve the digital divide. It's not going to do anything of the sort. In fact, blanketing all of LA with wireless towers is going to increase the digital divide. And as Scott points out, there are clearly climate change effects. In New York today, these towers are being thrust and impaled in poor communities, in African-American communities, and induced by the belief this is equity, diversity, and inclusion. It's a cynical attempt to hoodwink people and injure them without their consent or even their knowledge. And so this is what is transpiring in this country, across the country, and what we're trying to do in LA is to create some reasonable, powerful precedents that can be applied in many other settings and many other forums. So I hope that gives you, as I said, some subtext and context to how important this case is, because its applications can be immediate and powerful. Thank you.
Thank you, Julian. How great is it to have lawyers who are both brilliant and know the difference between right and wrong? Thank you, Scott. Thank you, Julian, for all that you're doing. We have our fingers crossed, of course, about the outcome of the court case, and we'll see what happens over the next few months. I'm going to share my screen as I go through a little bit of background on the two bills that are making their way through the California legislature. So right now, industry lobbyists from the wireless industry are walking the halls of the State House, having drinks with the legislators, playing golf with the legislators, telling the legislators how important it is to help close the digital divide, and how those pesky local officials in towns and cities all over California are getting in the way. So this is their basic pitch. It's time to get everybody connected. Wireless is the fastest and least expensive way to do that, but local government is standing in the way. We need to be able to batch our applications together, up to 25 at a time for small towns and up to 50 at a time in bigger cities. And if the local government can't get it together and approve all of them, every last one in the time we want, then we want them to be automatically approved. And oh, by the way, wireless broadband is just as good as wired broadband. So that's their pitch. Let's start with this. All broadband is not created equal. I think everybody on the call probably knows this, that wireless can never be the equal to wired broadband. And in fact, more deployment of wireless for broadband applications is simply creating another digital divide. And just for the sake of discussion tonight, when we talk about wired broadband, we're going to be talking primarily about fiber optic, although cable broadband is available in many places. But fiber optic is standard in the rest of the world. The rest of the world uses wireless for their cellular service for talk and text, and they use fiber optic to connect to the internet. So let's take a look at some of these other arguments. Wireless is the fastest and least expensive way to do this. There's an old saying that says, there's never enough time to do it right, but there's always enough time to do it over. Putting up antennas might be a little faster than running fiber optic cable, although I think there's a good argument to be had about that. And least expensive, come on, let's get serious. The wireless, if you want any kind of speed, is really expensive. You can get slow, crappy service with wireless, but slow, crappy service is not going to help close the digital divide. In fact, it's going to do the opposite. I love this. Local government is standing in the way. Of what are they standing in the way? Of unfettered, uncontrolled deployment of wireless antennas anywhere the industry wants? It's the job of local government to stand in the way. Government is the buffer between industry on the one hand and the needs of the people on the other. That's what government is supposed to do. Local government officials are doing their job, protecting the interests of the people that voted them into the office. Telecoms don't like it. Too bad. Let's take a minute and talk about antenna applications for a second. I don't know how many of you have ever seen a telecom application, but telecom applications are fairly complex documents. They've got, they can be 2-3 inches thick. They've got construction drawings, electrical diagrams, traffic control patterns, insurance certificates. They've got renderings of what the antennas are going to look like, photo simulations. They've got equipment specifications. So they're fairly complex documents. They're not easy to go through. Usually, depending on the local code, they may also contain propagation maps to show where the service is happening and where it's not happening in a particular community. And of course, wireless companies or the site developers that are applying for these antennas, here's a secret. They don't always tell the truth. My friend Andy Campanelli says he's never actually seen an application that was 100% truthful and accurate. The applicants want their applications to be approved. So they're gonna, fudge a little bit here and there to get them approved. This is where local government can keep an eye on how things are done. This is why we shouldn't be rushing applications. Another claim of the telecoms is we need to batch our applications together. We want to be able to dump a whole bunch of applications on the local office at once and have them go through all of them at the same time if they're similar. Well, who's going to decide if they're similar? The applicants apparently are going to decide if they're similar. So if they're all wireless antennas, as far as the applicants are concerned, they're all the same. What possible benefit does it have to the people of California to batch these applications together in big bunches? It has none. There's no benefit. The only effect of forcing the local authorities to try to go through all the applications at once is a benefit for the telecom industry. And under the terms of this bill, AB 965 that we've been talking about, if a local authority wants to pull out one or two of the applications because Maybe they're in an environmentally sensitive area, or maybe they're in a historical area, or maybe they're right in front of a school and they want to pull that application out. They can't. They can only pull the application, any one of the applications out, if the applicant agrees. What kind of law is this? Who came up with this? Well, we know exactly who came up with it, asking a rhetorical question. And this last point, we want our applications deemed approved if time runs out. The wireless industry already tried this with the FCC. They went to the FCC and said, please, when you put in the shot clock, can you make sure that the applications are deemed approved? And the FCC said, no, we're not going to do that. We don't think it's fair to local authorities. You have a perfect remedy. If the local authority doesn't approve your antenna in the time frame that the FCC has set, then you can go to court and have the court grant you the permit. I will just say quickly that we need to recognize that FCC orders and FCC regulations are not really the law. They're the FCC's interpretation of the law. And from time to time, those interpretations get challenged. And sometimes the FCC loses and sometimes they win. But putting local governments under a time crunch with the combination of putting in all these antennas at once and making them to have to approve them within a certain amount of time is an unreasonable burden that's being put on local governments. Now, there's another interesting part of the law that says, well, if the local governments need more help, the applicant can volunteer to provide more help to them. Does that sound like the fox guarding the hen house? It does to me. So that's a review of 965. Now let me talk a little bit about AB 1065. I've got the picture here. I call this the greedy little sticky fingers bill, because this is the telecom wireless industry trying to get their hands on money that was intended for fiber optic broadband to the premises. So obviously there's a national push to try to close the digital divide, get underserved and unserved communities connected to broadband. I think everybody supports that idea. Fast internet is no longer a luxury. A fast internet is a requirement of the 21st century. It's no longer a luxury. Everybody needs to be connected. The Biden administration in its infrastructure bill set aside a lot of money for broadband, for connecting these underserved and unserved communities with high quality internet. High quality internet, not any internet. The National Telecommunications and Information Administration, part of the Biden administration, which is administering the $65 billion, has specifically said that priority should be given to projects that are based on delivering fiber optic to the premises. So the people who are controlling the national money, there's also some state money involved, but the national money is supposed to have this priority for fiber optic to the premises. 1065 wants to open this up to the wireless industry. Wireless industry wasn't happy when the NTIA came out with that announcement. They immediately got on their corporate jets and flew to Washington and said, what the heck are you guys doing? They tried to convince the NTIA to drop that, but the NTIA stood firm. And so that money is supposed to be used for high quality projects. Now, the lobbyists in Sacramento are saying they're both the same. There's no difference. We just want broadband for everybody. So wireless and wired should be considered the same. You should let us get our hands on this federal money. And that's what AB 1065 does. It allows the wireless companies to be considered on an equal basis with the wired companies, with the fiber optic companies, to provide broadband services. So we think this is a really bad idea to use taxpayer money to build out the highly profitable, unregulated wireless business. And the California legislature just needs to say no. No, we're not going to let the wireless industry use the legislature to support this myth that all broadband is the same. So that's AB 1065, and that's kind of my overview of these these two bills, 965 and 1065. I'm going to turn this over to my friend Brenda Martinez to talk a little bit about the digital divide, and then we're going to ask Bill Allayaud from EWG, who has been so nice to join us on this call tonight, to talk specifically about how these bills are making their way through the California legislature and exactly how you can make your comments. It's really, really important that everybody on this call make comments and make sure that you get your friends, your family, your aunts, your uncles, even your kids, if you have old enough kids, to make comments. It's my pleasure now to introduce my friend and colleague and fighter for justice and equality, Brenda Martinez. Brenda is a community organizer in East Los Angeles and a founding member of Fiber First LA. Please listen to what Brenda has to say about wireless broadband and the digital divide. She has lived through it. Brenda.
Thank you so much. Thank you for the invitation, and thank you everyone who was able to make it. So, well, my name is Brenda Martinez, and many of you know me through 5G Free California and Fiber First LA. I'm also with Children's Health Defense. And so I'm going to speak a little bit about this digital divide and what is the digital divide, because we hear when they're pushing for these bills that they use that as an excuse on why they're really pushing for these bills, and keep saying that we need to give the unserved and underserved community the wireless connection that they need, and all of this great talk that they're using and excuses, right? So what is the digital divide? Basically, that lower income communities didn't get the opportunity to have the technology or the access to the technology. And so through this bills, they touted as a way to close the digital divide, which is not true. It is a big lie. We all know, we heard Scott, we heard Julian, we heard Doug. It is cheap technology. The having gazillion antennas near your home doesn't necessarily mean that you will have access to that technology. And the most important thing, I think, at this point, just talking in terms of the economic aspect of it, doesn't mean that you actually will be able to afford it. So they this makes me very upset, and I'm gonna be extremely honest with you guys. I don't like that they use lower income communities and say we're gonna close the digital divide and you guys are finally gonna be connected. Why? There is just one study right now that I'm going to talk about. It's a USC study by Dr. Galperin, and it's called Who Gets Access to the Fast Broadband? This study took 4 years, and what he did is he just collected information on different lower income communities like East LA, Pomona, El Monte, mainly communities of minorities. And he essentially said that he let us know through his study that the real solution of bringing this a real equal technology connectivity was fiber optics. But because we give the private sectors the opportunity to do so, they just simply don't see our communities as profitable. And so they completely skipped us. And so this same private sectors that skipped us a few years ago are the same ones that are going to be given all the opportunities to apply for all these permits and to get all this money. You know, so are they really going to close the digital divide this time? That is a big question. And so I wanna add that it's not just the fact that we are being used as an excuse. It's not just the fact that it's still questionable if they will really give us that opportunity to have access to close that digital divide. But it is important to know that they're trying to use this wireless technology, and they're trying to say we need to put more towers. I'm just going to give you an example of my personal experience. So prior to the pandemic, we had half a mile, well, 3 mile radius. It was like around 500 cell towers. I'm sorry, cell antennas in near my home. After the pandemic, we had over 2,700. We still had no connectivity. I was still paying close to 100, sometimes 200, and one time I had to pay almost $300 because we were all working from home. I had the kids doing schooling at home. Finally, one day my phone, my landline, got messed up. I called a technician, and the technician said, I started talking to him, and I said, "Hey, do we have fiber optics available by any chance? Do you know?" And he said, "Yeah, 2 blocks from here, you have fiber optics." And I said, "Well, how come I can't have it?" And he said, "Well, get your neighbors together and start asking for it because we have, AT&T." And so that's what we did. We started calling and asking, "Hey, do we have fiber optic? My neighbor 2 blocks from here has fiber optic." We were finally able to get fiber optics. So I'm able to stay in this call because I have fiber optics. But I'm also paying only $50 a month, and that's flat, and it's 3,000 megabytes. And I have no problems with speed. And people say, a lot of people told me, well, fiber optics, it's also an energy, it's not energy efficient. It's not true. My bill has not gone up, and I have perfectly good access. I can connect. I don't have to use Wi-Fi. I can just use the wired. So we we need to put pressure on some of our senators and our elected officials that we want a quality service. We don't just want service. It's like saying, "Oh, you need that? We'll give it to you." It doesn't matter the quality of it. So we need to remind them that's what these communities deserve. It's not just closing the digital divide. It's not just giving us anything. It's let's let's give quality a quality service and access to all of these communities, underserved and unserved communities. So I'm gonna leave you with that. Thank you so much for the invitation. So happy to be here.
Thank you, Brenda. A warrior for the light, as they say. I'm going to introduce now Mr. Bill Allayaud. Bill has led EWG's government affairs efforts in California since 2009. He worked for 20 years for the California Coastal Commission as a planner and legislative liaison, led Sierra Club California for 8 years, and worked as an analyst in the California State Assembly. Bill knows his way around the halls of the State House, and we are very lucky to have him with us tonight to talk about the legislative calendar for these two bills and how you can submit your comments and have your voice heard. Bill.
Thanks, Doug, and thanks the 55 or so people who have joined the webinar. And EWG is the Environmental Working Group, and we've had an interest in cellular and radiation RF for a long, long time. We advised people many, many years ago about the best way to use your phone, and those recommendations were mirrored in a Department of Public Health paper or a flyer that was put out a few years later that was suppressed. And Professor Joel Moskowitz of Berkeley sued and got that published, and it looked just like ours, like keep it away from your head, text, don't use headphones, don't put things next to don't keep it next to your body, especially if you're pregnant, etc. So these two bills, they've both already passed the state assembly. That's the AB, an assembly bill, and they're now pending in the state Senate. They go through policy committees, then a fiscal committee, if applicable, and then the Senate floor. If any amendments are made in the second house, the Senate, they have to go back to the assembly for concurrence. The deadline for these bills is July 14th. It's actually the 12th. There's no hearings on the 13th and 14th. So they have to be out of the policy committee then. Then they take a summer break, and they will come back in mid-August, go to a probes, and then the Senate floor in late August, early September. To the governor by September 14th. He has 30 days to sign or veto. I was involved in a bill by Senator Hueso of San Diego a few years ago with many people on this call. We got him to veto it. The main player, though, was the League of Cities and the County Supervisors Association. They had strong opposition to that. It was, again, shoving through 5G wireless through local government. Since then, the FCC adopted rules that try to streamline things and do that. This is their latest push by authors. Juan Carrillo is the author of AB 965, a former city planner himself. His staff tells me, he said, well, why are these batch things taking so long? They're all the same thing in the same neighborhood. They should go much faster. So that was his goal, was to write legislation that would force cities and counties to go faster. The second one we think must be also from the CTIA, the Cellular Telecommunications Industry Association, which is, Doug explained, they're trying to get their mitts on money that should have been, is set aside for broadband that's fiber cable. The bills, the cities, League of Cities may end up not being our ally on this, in that they oppose in the first house. They may very well drop out due to recent amendments by Mr. Carrillo in AB 965. That worries me because without the cities, the counties, and many legislators, Senate and Assembly, come from local government themselves, so they're sympathetic and understand the permitting process. Without the municipalities, it's going to be an uphill fight, to be honest, because the legislators, a lot of them go, well, what happened to the league? They're neutral now. We don't care that much. So the letters are due to this committee, Energy, Utilities, Communications, tomorrow by 3 p.m. The hearing is Tuesday, the 20th, I believe at 9:30. I didn't write down the time, but they're on next Tuesday. It's a big, big committee. I won't name all the members. The chair is Mr. Senator Bradford of Los Angeles. I'd say he's sympathetic to large utilities, and I would assume the cellular people. So it's an uphill fight. The other bill is double referred, 1065. No, actually, sorry. That bill will also have to go to Governance and Finance, formerly the Local Government Committee. So if it passes Energy, it'll go to Governance and Finance a week or two later. And letters for that committee are due, they meet every Wednesday. Letters for that probably due on late June. It depends on when they set the hearing. July 4th is a holiday though, so they'll either be on Tuesday the 27th or the following Wednesday. They'll have to move it a day if they have another hearing. They publish these agendas only a few days in advance, so we won't know exactly what happens until the action is taken, and a few days after that next week as to what happens next. So a lot of you are involved in letter writing, and I think that's really important. And also even more important, I know Doug has spearheaded some of this, is to try to talk to the legislators on these committees. If it gets out of these committees and they get, big votes, positive votes, it's going to be real hard on the Senate floor. And then you have to really slog through and go senator by senator. But if you start to raise the concerns and raise issues and get some no votes in these policy committees, then we have a chance. The second bill, 1065, we do have another ally opposing. It's the Utilities Reform Network, TURN, TURN. They oppose it because they said in their letter, this money was set aside for broadband that's hardwired, that's in the ground, on pole, not on antennas, not wireless. So that's why they're opposing it. I've contacted them twice to try to get where they're standing today, because an amendment in that bill said these funds may be spent on non-hardwired, in other words, for wireless, at the discretion of the Public Utilities Commission. So I'm asking TURN, are you still going to be opposed? Are you okay with that? Is that good enough if you say the PUC has discretion? But the PUC, they're all appointed by the governor. We think that they're often sympathetic towards large utilities like PG&E and Verizon, et cetera. So that's tough, but TURN is an important voice in the Capitol. They're bigger than EWG on this issue, to tell you the truth. I work a lot of toxics issues. That's why you're involved in this subject matter. But TURN has a strong voice when it comes to appearing before the PUC, how the money is spent and how decisions are made. So I'll stop there because I bet people want to ask some important questions. I don't know if I'm last even.
You are. Thanks, Bill. Ben, you can bring everybody on if you want. We have a question from Sydney. Are both bills in lockstep? Will they both be coming to the Governance and Finance Committee at the same time?
Only one will go to Governance and Finance, 965, because it involves the discretion of local government. The other one is the discretion of the PUC. It's single referred to just the Energy Committee.
And do we know what changes were made to 965 that caused the League of Cities to modify their position? Well,
They haven't modified it. Yes, the staff, their lobbyists said, we are looking at the amendment. We may go neutral. I'm guessing they will, but it's hard to tell in this business how people go, and they have to answer to committees in the league of made up of city council members and board of supervisors, members of the board. They can't the lobbyists don't make the decisions on their own. They have to go back and forth between their committees to get advice and okay. So I don't know yet. And he didn't answer me this week on my email, like, what are you going to do? Hearings coming up. Don't know.
Yeah. Scott, we had a question about, how can a batch of permits be a batch if every permit, every antenna application is different, isn't it? And what's the logic of what can we use to fight back against the logic of batching these things together?
Well, obviously we want this bill to just not pass so that we don't have to deal with it. There is already an FCC rule on batching, but it's far less onerous. There are always differences in these applications because they have to design the site to fit the specific place that it is going. The orientation of the antennas will be different. Sometimes the equipment itself will be different. Sometimes the frequencies that they use will be different. The way that they have to anchor it to the ground will be different. It may be a metal pole in one place, it may be a wood pole in another, and that makes a lot of things be different. So there will be, assuming the bill passes, there will be a lot of debate when these patches start coming in about what is substantially similar. If the public had a chance to weigh in on this and perhaps help the staff identify where several of these are different, then we would have more of an opportunity to kick some of them out. But on the other hand, if you assume that they are all sufficiently similar to be processed as a batch, then all anybody has to do is find one thing wrong with any one of them. And if you assume that they're all sufficiently the same, then that means the same thing is wrong with all of them, thereby justifying rejecting all of them, obviously within the shot clock deadline period. Batching is a really bad thing for those at the local jurisdiction. Like Doug said, these applications are very complicated. It takes 2 or 3 hours just to figure out what's in the thing, just to make sure that all of the pieces that are required by the local ordinance and rules are actually there, much less whether they are correct. It takes many hours to determine whether they got everything right. The electrical design is complicated. The structural design, which is key, especially in this part of California where you have seismic events, you actually have to have an engineer look at the structural engineering to make sure that it can withstand earth shaking that is typical of that area. And it will be very, very difficult for each jurisdiction to actually go through 25 or 50, as the case may be, and get them out the door within, the 60 or 90 or 120 day period that they have under the rules. It's just impossible for them to actually do it. Because remember, you're not just going to get one batch of 50. You may get 5 batches of 50.
That's right.
You'll get one from T-Mobile, you'll get one from Verizon, you'll get one from AT&T, and miraculously, they'll all come in at the same time. So it will be an extraordinary burden on the local jurisdictions. Obviously, the incentive will be just to take it from the inbox, flip through it a little bit, stamp approved, put it in the outbox. And that's what this is all about. It's just another effort to make it a rubber stamp.
Bill, if people want to submit comments to the Senate Energy, Utilities, and Communications Committee, how do they do that? And I noticed there was a deadline of tomorrow, but what's the mechanism by which they go through? Is there a website or portal or something?
Yeah, through the last few years, they've made each committee, if you go to the Senate webpage and click on committees, you'll see the Energy, Utility, Communications one, and click on that, and they'll see, here's our portal for submitting a letter. And you have to register to use that portal, but it takes a minute. You just have to get a password. So all the letters have to go that way. They can't go to just the chair or the room number anymore. It has to go through the portal. And that's on the webpage.
So we're going to go to the California Senate. We're going to look up committees. We're going to look up the Senate Energy, Utilities, and Communications Committee. We're going to go to their portal. We're going to register to put something in, and that's how we're going to submit our comment.
Right. And it's helpful if you can to make a one-page letter, like bullet points, because other people are going to be writing stuff. The analysis will cover some of this too. But I know some people submit longer letters, which is good for the committee analysts, the staff, because they can draw on that, saying opponents say, supporters say, opponents say. We want to give them some bullet points to work with.
And how about sending letters to the, Julian, just a second. How about sending letters to the individual members of the committee?
They're distributed by the committee so that you don't have to do it. So they get copies of all the committees. I believe I've been told that, and so each one is getting copies of. I think in this hearing there's only about 8 bills being heard, so it's not a massive. Now they can do 38 bills in a hearing, so this is not a big hearing.
Is there a downside to also writing directly to the senator?
No.
Okay.
Nor calling and saying I'm opposing that bill. Can you? And they'll say, well, we'll write that down if you call the Senate office. But don't send it to the general mailbox, Senator so-and-so. It's scn.ca.gov. It gets lost in that, an email.
Okay, so what's the best?
The letter through the portal of the committee.
Yep.
If you have time, call the senator office of each one of those. I think there's 14 or 15 in this committee, saying, hi, I'm so-and-so for the bill being heard next week. We're opposed to AB 965 and AB 1065. And they'll mark it down. They keep a tally in each of these offices.
All right, good. Julian.
Again, following my observation about looking at these issues from a systems point of view, I hope the people listening to this understand that the first part of the presentation by Scott and me, and the second by you, Doug, and the others in regard to these two bills are really intimately tied. That these need to be looked at together, because if these two bills pass, particularly 965, all the issues that Scott and I and Mitchell Tsai and his colleagues are litigating will become even more intense, even more intransigent. And as Scott pointed out, from the point of view of the planning department, it's going to be an almost impossible task that this bill is going to thrust upon them. As you point out, that Verizon, AT&T, they're all going to show up at the same time with their batches. And the planning department's going to throw up its hands. And if it had a strong propensity to rubber stamp, it's going to rubber stamp it even faster. So that's why this is pernicious. It is part of a larger process to thrust wireless upon these communities. And I thought Brenda's comments were really interesting because they give you a very granular, right at the family level, about how false these claims are about solving the digital divide. So this is going to happen in far greater intensity than we even imagine of these two bills, this being what we're litigating in LA. Now we have offered a solution to the planning department, and Scott and I and other members of the team produced a red line for the planning department on these ordinances to show precisely how practically they could comply with the shot clock and do their duty, do their responsibility. What's going to happen now as a result of the bill, they're going to be even less inclined to want to get into the weeds and come up with a practical solution. They really don't want to have a practical solution. And I think that's the most important point. They don't want to know about the harms, and they don't want to have a practical solution. They just want to do the bidding of the telecom companies. That's it, plain and simple. And so what do we do about a situation like that? That's what all our comments are trying to address.
Exactly. I think it's really important. We've been doing some lobbying meetings. Brenda, Jody Nelson, and I have been meeting with members of the staff members and legislative directors to the members of the Energy, Utilities, and Communications committees, and we've been talking about how unnecessary these bills are. They're completely unnecessary. The system is working. The FCC has its, its shot clocks. Local authorities are approving antennas. You can tell because they're all over the place. So, the system is not broken. It's not as though it needs to be fixed. I did want to mention before I forget that our friends at Environmental Health Trust have got an automated letter writing tool that they've set up so that you can send a letter to your legislator. Ben, can you put that in the chat, please? That link. Again, and we're very appreciative of Environmental Health Trust for doing that for us. I don't know whether CHD also has a letter writing tool. Brenda, do you know what CHD is doing on this? Are they going to?
Yes, we have an action alert, and we had already shared with many of the organizations, and we'll put it in the chat. I think Jody has it. I'm gonna try to find it. But yes, it's an action alert, and we're planning to do it at the national level because they're not requesting any zip codes. And so that way, again, I think the numbers makes a difference. So if we have gazillion emails, even if they click delete, they will still see that there was gazillion emails there, in opposition. So
That's great.
we do. I'll put it in the chat.
So you're encouraged, because that was one of the questions in the chat. So you are encouraging people from out of state to send letters in.
Yes.
Okay, great.
Thank you.
Excellent. We had a question early on for Scott or Julian. Can Big Telecom put an antenna anywhere they want on a PG&E pole, even on private property, without the owner's permission?
Well, who's the owner? That's the problem.
Right. That's what I wanted to get to.
Many times people do not remember that there's oftentimes a strip of land in the front of their house that is actually part of the right of way. And much of the time, they don't even own it. The city or the county will have a fee simple ownership of that little strip of land. And so the owner would be the same entity that's approving the permit and is getting money in rental for occupying that land. Now, other times, and this is also true in lots of places in California, it won't be right of way, it will be what we call an easement. And there, the person who owns the home does technically own the land going all the way out maybe to the curb. But the utility company, say PG&E or SCE, will have an easement or a right to occupy and cross the land to place their facilities. And I have seen debates throughout the country over whether the easement that's granted to an electric company can just be automatically extended to a wireless company that's putting equipment on that pole. And there are cases that go both ways. But if you do see one of these, and if you know that that land in front of your house is an easement, then the first thing you should be doing is looking at your deed to see what your easement says about what this utility company can do with that land. Now, finally, there is also, of course, that part of your land where there's no right of way and no easement. And fortunately, at least today, the answer is no, they can't just come and stick something in your own property without your permission. They have to pay you. They have to negotiate with you.
And one terra incognito which is the subject of current litigation brought by our colleague Harry Lehman, is that in some cases there have been a return of the easement to present holders. In that case, African-American community had it deeded back to them. They didn't even know it. And so but then they informed themselves, and the telecom company was essentially operating without any right of easement. And we're investigating how many of these situations, similar to the Harry Lehman's case, exist in Los Angeles County. So that, if that is the case, that in many cases, telecom companies are operating without the authority of an easement, it would be very, very significant, but we're not there yet to be able to say so.
Mhm. Somebody wanted us to repeat the information for putting your letters into the portal, and I think I have this down correctly. On the if you search for the California Senate and go to committees and click on the Energy, Utilities, and Communications Committee, there you will find an opportunity to submit your comment through the portal. You do have to register, but it's not terribly onerous. And we've had a lot of suggestions of things that you might put in on the art website. Ben just put into the chat. We've got our our fact sheets, if you want, on 965 and 1065 that will give you some helpful hints in crafting your letter. And again, could someone please outline the deadlines for each of these: phone calls to the senator's office, letters through the legislative committee portal, and a letter to the senators and their committee members? Bill, can you?
I'm looking at the Energy Committee website right now. Right dead center is a big red tag that says submit position letter. That's the portal entry. As far as phone calls, if this is being heard on the 20th, Tuesday, calls anytime this week are good. They'll be tallied. Actually, starting, where are we now? We're the 12th, 13th. Yeah, starting now is good. I mean, anytime leading up to that hearing. Don't do it Tuesday morning, the 20th. Do it before that.
And isn't there a deadline of tomorrow afternoon at 3 p.m.?
Correct. Tomorrow at 3 for both these bills in the Energy Committee. They have the right to ignore your letter after that. They may or may not. But if we get 50, 60 letters in, they could just say, these didn't make the deadline, and forget them. Your name might not appear either. It can say certain groups plus 45 individuals, then it won't list them all.
Okay.
So if you're not in the analysis, which comes out, you probably won't see it till Monday the 19th, which is supposedly an impartial analysis of the bill done by committee staff who serve at the pleasure of the chair. That's how it works.
Okay. We've been asked for, Julian.
We're in this program, we're really providing information and ideas in the dialogue at several levels. One is very, very practical. Who do you write to? What's the process? How do you frame your letter? What should be the key arguments? The second level is sort of background on the litigation, background on the two bills, and so forth. And then the third is this a bit more abstract, but I think I'm trying to indicate very useful sort of larger context. The critical value that's being asserted here is speed, which is not challenged by anybody. The premise of this legislation and in the actions taken by the Board of Supervisors, we got to rush this all through. Well, why do we have to rush all this through? Who's going to benefit by rushing it all through? That's a value, a deep value that needs to be challenged. I'm involved in a project which involves 10,000 cities around the world called Gaiapolis, which is emphasizing quality over quantity. We talk about economic development, but we never think of it in terms of quality of life for the inhabitants of these cities. Why are we rushing all of this? For whose benefit? Well, it's obvious for whose benefit is these companies want to profit, and the more they can ram on in terms of communities, the more profitable we be for them and their shareholders. But speed does necessarily serve the well-being of the communities. So when we're crafting these letters, it perhaps is important to realize that there's a value system, that a set of values are being thrust and imposed through the throats of everybody. And on top of the list that everything has to go faster and faster, heedless of the consequences of it. And so I think that's at the root of what is at stake here. Who says that collective happiness of these communities is best served by rushing through densified cell towers and ramming them into minority communities? Anyway, it's perhaps a bit theoretical, but I think it's at the core of what we're talking about here.
We've had some comments about people asking why we're not giving people content. And my only response to that is this entire program has been about the content of what you might want to put into your letter. We're not going to tell you how to write your letter or what to write your letter about. But certainly Julian and Scott have talked about, values and, where we put our emphasis. Brenda has talked about the digital divide, a critical issue for unserved and underserved communities. And while we're on that for a second, let me just say that there's one of the things that telecom seems to be pushing in Sacramento is the idea that if you're out in a rural area, forget it, wireless is the only solution. I've reminded these people that the wireless antenna is going to require the fiber optic cable to it. And if they're going to run the fiber optic cable to it, they can run it a little further and take it right to the premises. It's not prohibitively expensive if people have electricity and they've got poles that they can string fiber optic on. Not all fiber optic cable needs to be buried. The fiber optic cable that runs outside my house runs on telephone poles, as it does all over in this particular area. So we've been pushing back against that. We had one legislative aide tell us it's going to cost $5,000 to connect every in the rural community, and I think that's not necessarily true. So we've got these issues. I'm sorry, Brenda.
I just want to say one thing. I just want to make a quick point, and to everyone out there who is open to talk to their senators, or who has the possibility, who is willing to make a phone call. This whole digital divide, you're using the digital divide as an excuse. I would like for you to tell them that our communities are overloaded with cell towers, antennas, and we still don't have the access. So how are they planning to close this digital divide? If they're just going to add more antennas, we're going to be in the same situation. We're just going to be worse because of everything else we've discussed on the side effects of these antennas. But why are we right now the area for digital divide if we have so much coverage? Why did they consider us a digital divide area? I mean, that's a question that we posted to some of this letter senators, representatives, and no one seems to know the answer to that, So I just want to put that out there. Thank you.
And another point that Brenda usually makes in our lobbying meetings is she doesn't think it's fair for the wireless companies to use the digital divide as the excuse to put in more antennas everywhere. It's clearly they're leaning on this and trying to convince, and the digital divide is kind of this nebulous thing out there that isn't clearly defined, to the point that was made in the chat a few minutes ago. There's no definition of the digital divide. Everybody's got their own interpretation of what it's done. Keep in mind that these bills are already written and have already passed the assembly. So asking for language changes, we can do, but it's not, I don't think we're likely to succeed with suggesting specific language changes. I'm hoping, and Bill, maybe you can address this, I'm hoping that people will somebody in the Senate will suggest an amendment that will mean it has to go back to the assembly, so that we can so that we can get a chance to talk to some of the assembly members, because I'll be honest, we were late coming to the issue. By the time we got involved, it was pretty much a done deal in the assembly. So we're working hard in the Senate, but I'm hoping to have a chance to go back to the assembly and work some of those members as well.
Good way to get an amendment is if somebody in one of these committees has to question, why aren't you considering this? And the author has to say, here's why. He'll have his supporter next to him, which is the cellular people, to answer that. But we plant those seeds and get it going, especially for the bill that's double referred, because it's going to a second committee, the one on local government, which we think has a big impact on local planning.
Okay, why aren't you considering this? So we should try to think of all the things that they might they've missed here. And
Can I add just one more thing? I just want to add that one good argument that you can also do with your senators is that the difference in payment. So we were paying $100 for Wi-Fi, but with fiber we're only paying $50. And in some cases, if you qualify for the Affordable Connectivity Act or program, you actually can pay up to $30 for like 1,000 times the speed. So I think that's a really good argument that has to raise some eyebrows in some of these legislative representatives. So just thank you.
Bill, somebody's commented in the chat that that 965 was already amended in the Senate.
Yeah, they took that amendment after it passed the assembly floor. That's the amendment that they're trying to use to get local government to neutral.
So does that mean it has to go back to the assembly for a vote again?
Yes, good point.
Okay, great.
I'm double checking that now to make sure it did happen after the first of the year, after it left the assembly, but I think it did. I know it did.
Okay, well, that would be great. So
it was amended June 7th, and the vote in the assembly was on May 22nd. So clearly it'll have to go back to the other side. Now, if there's no controversy, you can get on the consent agenda, but generally they run through them, but it'll have to go back.
We're going to try to make as much controversy as we can. That's our job.
Well, and it can be re-referred back to the committee it came out of in the assembly if they want to take a look at it. The committee has to ask for it back. They have to go to the rules committee and say that amendment we want to discuss in committee because it affects our jurisdiction, our local governments. And they can ask rules to re-refer it back to policy committee. It doesn't happen every day because it's at the end of the year and they're trying to get through all these bills. Sorry.
That's okay.
Got a phone call.
Our time's almost up. Somebody wanted Brenda to explain why people still don't have access with even more and more antennas in place. It's unaffordable for many, and or the wireless technology is inadequate. Do you know why you couldn't get connection even with all those antennas in your neighborhood?
It's not accessible. Everything is expensive. We only have one company that offers that. If you want, the other choice is either cable TV, and it comes with a big package too. So it's either that or AT&T, and AT&T did not had it available, and so it's either that or through your cell phone company that you get a hotspot, or you pay extra for the hotspot so that other people can use your Wi-Fi in your home, or paying $100-something for AT&T services.
Yeah. Bill, do you have a thought about talking about the health impacts of exposure to RF radiation in our letters to the legislature? You're muted, I think.
I think it's definitely worth mentioning that, a couple lines about X studies show biological impacts from this radiation, which is being ignored by the industry. The federal government's regulations on allowable radiation levels is way outdated. Obviously, pressure from the industry keeps it that way. And for me, I have wired fiber optic on my telephone pole behind me, a horizontal wire running. They brought it to my house. I don't want a 5G antenna, dropping another wavelength into a sub-millimeter wavelength into my house. without my permission. I will not subscribe to it. It'll still be hitting me. And I don't think that's fair. It's kind of but their attitude, most people ask is, well, who cares? It doesn't hurt you. I don't know that it doesn't hurt me. There's enough evidence to say, I don't want it. I know that.
Yeah, good. Okay, so you've heard from the experts tonight. I want to thank Julian and Scott for their review of the case that's going on in Los Angeles. We've all got our fingers crossed and hope we get a good response, and that we can respect the CEQA law, and the environment is really, really important, and we can't just override it whenever we want to, which we seem to be doing these days.
Can I say just one last thing?
Sure.
Sorry. I have
Brenda's
to
always
say
got
this.
one more thing she wants to say.
Thank you. It's just that I heard this comment on the call, the New York City, and I heard someone saying, we need the cell towers, we need those antennas outside of the streets because most people don't have access in their apartments, and New York has a lot of apartments, and so does LA, and we don't have access on our apartments, and there's usually a business on the first floor, and so if someone is using the business on the first floor, they will have access to the Wi-Fi antenna that is right outside the business, and so we need those antennas there. And I thought that was very interesting because if the business had Wi-Fi, mind you, the antennas out there, the companies will be making millions of dollars from that antenna, and the business and everyone else will be having to connect to that antenna. But if we had fiber optics to the homes, they wouldn't even have to pay for that. And if we had more programs, they will probably have to pay a very small portion. And the business will be the one making the money and not the big multi-million-dollar companies. And so I just thought it was very interesting how some people think of the antennas as a necessity when you haven't even think about exploring anything else. So I just wanted to put that story out there. Thank you.
Once they have fiber optic, they'll be spoiled. So thank you, Brenda. Thank you, Bill. I really appreciate your being here. Your knowledge is super useful to us. And we're going to probably call on you again. Thank you to all of you who attended. The link to the video from tonight will be up. Probably you'll get that link sometime tomorrow, as soon as I can get to it. So thank you all for attending. We very much appreciate your interest. Please, please, please make your voices heard in the California legislature. We need you to weigh in and let them know that we really care about this issue. Thank you to everybody who attended. Thank you to our panelists. Good night, everybody.